Okay, so this is my name. It's unpronounceable in English. It's actually better in Czech, so it's Gijs van Dijck. And if you don't know, just call me whatever you want. The problem is, the legal problem is pretty simple, right? So here's Tom Cruise playing Jerry Maguire, and Jerry Maguire is an agent of an American football player, and it's his only client, so he has to, you know, keep his client. And the client wants him to yell, "Show me the money," and it kind of indicates, and that's what he's doing in the movie, right? And it kind of indicates what the problem in insolvency is, because we all know that the problem of insolvencies and bankruptcies is that there's no money, right? Or at least there's a lack of money. So what to do with that? Because these insolvencies need to be wound up, they need to be liquidated or administered, and there's human interactions involved, and a characteristic of humans is that they want to be paid for what they do. All right, so that's the problem. And now in words. So why care? Why care about this issue? We have insolvency representatives, and they're responsible for liquidating the estate, for administrating the estate, to wind up the estate. Right? It's the core piece of insolvencies, basically every system. But insolvency representatives, they need to be skilled and they need to be paid, right? If we don't pay people, then they won't do anything. But the problem that we encounter in basically every legal system that I've seen and observed is that there's often a lack of assets. And this problem is so big that we do not have enough sufficient assets to pay the insolvency representative. There's a lack of incentives for other stakeholders. Creditors already lost their money, so they're not going to invest in winding up the estate. Why should they? Shareholders, there's no interest there. There's no interest of society. We need to get rid of these bankruptcies, right? And who's going to pay for them? Nobody. So the result is that the winding up of the estate is in danger, right? If we don't pay insolvency representatives, problems will exist. Entitlements will not be enforced, creditors will not get what they're entitled to, the causes of insolvency cannot be determined, which means there's no lessons for the future, investigations cannot be conducted, and that's a societal problem because we do not have any lessons for the future. There's no lessons for stakeholders, there's no lessons for creditors, for future debtors, for the government, for everybody who's involved in an insolvency. And there can be a problem of what we call bankruptcy gambling. If you have a bad bankruptcy system or bad funding of bankruptcies, then the problem can emerge that, you know, these debtors who are basically bankrupt can still go on and continue their business, which can lead to a problem. I will come back to this issue later. So what I did is I collected some information, preferably empirical information, from several legal systems to see how they deal with funding insolvency representatives. Because I noticed that there's some information in these several legal systems, in the various legal systems, but this information has not been integrated. So different models are applied, but we do not know which model is the best. And I'll promise you, after this presentation, we still do not know which model is the best, but at least we'll probably know a little bit more about it. I'm going to discuss three models: insolvency, state funding, and not opening insolvency procedure, and it kind of represents three countries. The first is what we do in the Netherlands, my home country. State funding is what the UK does, and not opening an insolvency procedure is an example of what we see in Germany. This is not a mistake, but it just doesn't work, right? So I'm not going to bother you with this idea. Third-party funding is that there's an outside party who's going to fund the winding up of the insolvency. Can be the government, can be stakeholders. It just doesn't really work. So I'm not going to talk about it. And those who want to know more about it can read my paper, included in reference at the end of the presentation. All right, so let's get going. Insolvency estate funding. So the insolvency representative's fee are paid from the estate. All right, so from the available assets, you first go to pay the insolvency representative fee. It's often an hourly fee. depending on asset size and experience. So the more assets are available, the more the insolvency representative gets, and the more experience the insolvency representative has, the more he or she will get paid. All right, this you can read later in the paper or on the presentation that will be distributed. What's important is this. So these insolvency representatives suffer from assetless estates in the Netherlands, but also in other countries. So creditors do not recover a lot, and bankruptcy trustees are in trouble as well. So what I found is in the Netherlands, there's no full compensation in 32% of the cases of consumer bankruptcies for insolvency representatives. And it's 61% or 65% if you talk about corporations. So in around 60–65% of all insolvencies, the insolvency representatives are not fully paid. And what we see is salary certificates of 1,000 euros or more in more than 40% of the cases. So in more than 40% of the insolvencies, the insolvency representatives do not get, not only get their money, they also have a certificate of 1,000 euros or more. And that's a lot of check rounds. And there's substantial salary certificates in over 50% of the cases. And sometimes these salary certificates exceed 10,000 euros in approximately 10 to 20% of the cases. So individual bankruptcy trustees, individual insolvency representatives lose out on 10,000 euros or more in 10 to 20% of the cases. Quite substantial. And what's kind of shocking is that the hourly wages that these insolvency representatives have are extremely low. They're extremely low. So I found a mean of 62 euros, an hourly fee of 62 euros. And if you compare that to lawyers, so in the Netherlands, all insolvency representatives are lawyers, the mean hourly wage of lawyers is between 153 euros and 212 euros, right? And this applies to 90% of all lawyers. They charge a fee of between 153 or 212 euros. And if you compare that to a mean of 62 euros for insolvency representatives, it's extremely low, right? But interesting thing is they still come in fancy suits to all these nice conferences. So I don't know what's going on, but that's on the side now. All right, so what's the problem with that? The problem, there's at least 4 potential problems, and we observed them in practice already. One is with the performance, right? There's not going to be a lot of performance, a lot of activities in these assetless estates. If you know you're only going to be able to charge 62 euros an hour, while as a normal lawyer you would charge between like around 200 euros, you're not going to work as hard. A crowding out effect. So we see lawyers, insolvency representatives crowd out of bankruptcies. So they do not want to act as an insolvency representative anymore. The only thing they want to do is to advise the other parties before the bankruptcy, because that's the moment where you can actually get some money out of it. Oh. We also observed that insolvency representatives start to refuse appointments. They do not want to be involved in these assetless estates anymore. They only want to have the rich, the fat insolvencies where they can actually make some money. And the other thing is that, the other consequence is that what we see is excessive claiming, right? If you cannot claim your money in these assetless estates, you'll start compensating in the rich, in the fat bankruptcies, right? Where you can actually get some money, which is bad because it goes at the expense of the creditors in those wealthy bankruptcies, and it goes to these lawyers who should be compensated in the other bankruptcies. All right, so some problems with insolvency estate funding. So an alternative is state funding. And it is what it says. You know, you have a state, and the state funds the winding up of the estates. So how does that work? There's 2 versions of it. It's for the winding up or the liquidation or administration, whatever word you prefer. And you can use it for specific actions, but as I said in the beginning, that doesn't really work that well. So I'm not going to discuss that part. So I'm going to focus on the winding up, on the liquidation or the administration of insolvencies. All right, So in England and Wales, you have official receivership, which means that an official receiver is appointed by the court. It's a state representative, and that person is a provisional liquidator. Right? It's an interim receiver in personal bankruptcy or a provisional liquidator in corporate insolvency. And what that person does is assess whether this is an assetless estate, if the estate contains sufficient assets or not. If it doesn't, then that person will wind up the estate, him or herself. If the asset does contain substantial assets, then it goes to an insolvency practitioner, right? The system as we know it in my country, but also in this country. It goes to a professional, to a private professional. So in 2013, there were 42 official receivers at 35 sites in 7 regions. It's for your information. And this table shows the numbers of cases that they're dealing with. And what to show you is how much it increases over time. And this is okay because this is the number of completed cases, but look at this row, right? So this is the number of incompleted cases starting at almost 38,000, and in only a few years it increases to 88,000 cases. So at this point of time, there's 88,000 incomplete cases in the UK, which can be a problem as well, because when these bankruptcies are lingering, there's a lot of creditors who can suffer from that. So basically the message is, if you adopt this system, appoint enough official receivers, right? Otherwise you'll run into trouble. All right, so what we see is that this system is self-financed. It can be self-financed, because what they do in the UK is they impose petition costs, right? Petition costs on the insolvency. So when the creditor applies for insolvency or the debtor applies for insolvency, then you have to get a fee. And what you also see is that these fees, they kind of go up, right? And the problem of that is, you know, if nobody can pay the fee, then there will be no bankruptcy and it'll still be lingering, right? So the fees can be a problem. More tables, and this is like, I think, the more interesting table with respect to state funding. So what we see here is how they get the costs back. So for the first £2,000, there's no costs, right? There's no amount of money that goes to the state that will end up with the liquidator. So basically for the first 2,000, 2,500, depending if you're dealing with personal bankruptcies or with corporate bankruptcies, there's no fee imposed. But then it goes up. The next £1,700, it's fully for the state, and the next £1,500 is 75% of the state, and the next £396,000, £1,000, 15% goes to the state. Right? Don't ask me how they come up with £396, with £1,000, I have no idea, right? But you see, like, this system kind of guarantees that there's a money flow coming in, right? And it's just a matter of redistributing the money that comes in, and you can redistribute it among the insolvency practitioners in the assetless estates or the official receivers. And here you see that it's kind of cost efficient. So over some years, you see that this is the number of cases, this is the income, and this is what they spend on basically the winding up of these estates. So in most of these years, it's kind of cost efficient, except for this year, and it's probably because of the drop of cases going from 78,000 to 58,000, right? So you see a big difference here. But it's an interesting system because, you know, you can just throw up the percentages or the amounts, and depending on what you need, you can just reclaim it in the insolvencies, right? So this works in terms of finances and stuff. All right, then we go to the third system, which is applied by Germany. It's just not opening an insolvency procedure at all. It's a fairly easy solution. If there's not sufficient assets, there's no insolvency procedure. And what you see here is that the German Insolvency Code prescribes that the court shall refuse a request to open an insolvency procedure, so there's no margin of appreciation. It's not, it may open an insolvency procedure. The court shall not open an insolvency procedure. Others may provide for the cost, but as I said, there's no real incentive to fund an assetless estate, to fund the winding up of an estate. So nobody really does that. And the consequence, the legal consequence, is Auflösung, which means that there's a loss of legal competence to act. So the company still exists, but it has no power to do anything. It cannot continue trading. It cannot contract other parties. It has no legal competence to act whatsoever. And what we see from an empirical perspective is that there's average refusal rates of between 35 and 46%. Right? So in between 35 and 46%, there's no insolvency procedure of all these bankruptcies, which kind of resembles the data that I found in the Netherlands, where there's also a lack of assets in these percentages of cases. All right. So what happens is that the companies themselves and the directors who cause the financial mess, they are in charge of winding up the estate. And that has some interesting empirical effects if you let them do that. So creditors are left behind. The debtor lost his legal competence. There's basically a vacuum in the black hole. And there's incentives for these company directors to deplete companies' assets. Right? You're in charge, there's assets, you have no legal competence to act, so what do? Well, you can, move these assets to your friends or to daughter companies or whatever. So what we see in practice is that there's a large gap between the existing assets and the actually realized assets. So some researchers started to look at what assets are available at the time of the insolvency petition, and then looked at the assets that were distributed among the creditors at a later point of time, and they found a huge difference, right, which kind of supports the idea that these company directors are depleting these companies' assets. And the researchers calculated that creditors miss out on tens of billions of euros because of this. And what you also see is that in Germany there were somewhat over 1,500 debtors who successfully initiated consumer bankruptcy proceedings, but there were 2.77 million over-indebted households, right? So there's a lot of people, a lot of consumers with financial trouble, but only a very few of them will file for bankruptcy, right, in this system. So they kind of tried to remedy it, and you saw a rise of the number of cases from almost 1,600 to 13,000 to 70,000 because of that remedy. But there's still a huge difference between 71,000 and 2.77 million, right? All right. So, to evaluate that third-party funding, don't expect any miracles of it. It doesn't hurt anybody, but don't invest a lifetime in developing a policy on this thing. It can solve a little bit of the problem, but not fully the problem. All right, so insolvency estate funding, there's a problem with that because it's a vulnerable mechanism, right? You can adopt it, but it's especially vulnerable if there's a high number of estates that lack assets, and what I've seen in most countries is that most countries have a lack of assets in a substantial number of cases. State funding is self-financed, which is good news. But it's based on cross-subsidization, right? Which means that you get the money from another insolvency and use it in this insolvency. And the normative question is then, is it really a good idea to use money from other creditors to pay the winding up in this insolvency? What's the rationale? What's the theoretical justification for that? That's difficult to come up with. So this system has some normative implications, but from a financial point of view, it works. Which may be counterintuitive because, state funding is not something that most systems like. Right, not opening an insolvency procedure, the problem with that is that it reduces the burden on the judiciary because they get less cases. So you kind of solve the problem by sticking your head into the ground, but it introduces a lot of undesirable incentives, especially the bankruptcy gambling, that companies will just deplete the assets, so there's no problem because there will be no bankruptcy filing, and when there will be a bankruptcy filing, they'll just solve it themselves and deplete the assets anyway. So risky procedure. So as I promised, We do not have a solution at the end of the presentation, so my conclusion is pick your poison, right? So we have 4 systems, 3 or 4 systems. There's no system that is perfect. But if you would ask me, I would say the state funding with a little bit third-party funding would be okay. But maybe you should not call it state funding because that introduces new deterrent effects and negative effects because, you know, if you can get money from the state, everybody loves that. While if you get money from other creditors, that's a little bit more tricky. People become more ethical, right? So you could choose for a mix where you use the estate to fund insolvency representatives, but on top of that, you get an extra fee and you use it to throw it in the box. And if insolvency representatives need some money to wind up the estate, then you can withdraw that money from that collective, right? So that's kind of a combination of insolvency state funding and state funding. All right. So as I said, pick your poison. And if you want to read more about it, here's my reference. I don't know if this PowerPoint presentation will be distributed. It's fine. Otherwise, you can email me as well. Find me on the internet. The positive thing about my name is that there's only one person with that name on this world, so I'm easy to find. But if you get this PowerPoint presentation, you can just click on the links and you'll find the paper. And I'll be happy to answer questions if you have any. Thank you.
Thank you very much. Já bych se zeptala, má někdo nějakou otázku? Byli jsme vyzváni? Tak,
please in English, so you don't embarrass me, okay?
In English?
Thanks. So I would like to ask, you are here, so hopefully you know the Czech system. If you have any comments on that?
I think my knowledge is very limited. I asked how that works. I think you have a combination of not opening an insolvency procedure with
the estate funding.
Yeah.
Yeah.
And I don't know. I mean, the same thing applies. I don't know. You should collect some data on how many estates are here that lack substantial number of assets. I don't know what the empirical data on this is. I would predict it's kind of the same as in every other country. So I would say the same as I just said. I would adopt a model of state funding in combination with insolvency estate funding.
And the other question, especially in the consumer insolvencies, we see, because in our system, the trustee or administrator, however you call it, he's paid his first in the allocation and he has a fixed payment, a monthly fixed fee, I would say regardless of how good he is or how good he acts. And this turns to some groups of insolvency trustees wanting to have as many cases in insolvency, especially consumer insolvency, as possible. So if you have seen this anywhere else, or is it just our specialty?
No, I mean, you have these kind of insolvency mills, right? So you collect a lot of cases and then it becomes sort of profitable because the fees are generally not that high. So I think in consumer bankruptcies, there's another problem. And I don't think consumer bankruptcies is that much of a legal issue, honestly. It's more of a societal problem. These people who end up in consumer bankruptcy, they just have more psychological problems or societal problems. They do not know how to deal with money. So the question is if you should really focus that much on distributing money among creditors. I mean, it's important for creditors, but empirical research also shows that creditors don't really care if they get like 10 euros or 15 euros. It only matters if you go from 10 euros to 100 euros. So why put a lot of effort in making the assets as large as possible and then distribute it among the creditors? Maybe you should focus more on really how to help these people, regardless of what these creditors get. So I think consumer bankruptcies kind of need a totally different approach compared to corporate insolvencies, where money plays a bigger role. So though that's not like a very specific advice, but that's what I would focus on. I would focus on what are these people who wind up the estate, what are they doing? Are they just collecting money, or are they trying to really help these people? And if they're not helping these people, try to make up a system that really helps these people to prevent future bankruptcies.
Thank you.
Second.
I would like to make a point regarding timely bankruptcy petition. Basically, there are two tests for bankruptcy declaration. One is liquidity test, and the other is insolvency test. There are plenty of companies that are lingering on with timely petition for insolvency reasons. They do not recognize in time they have capital in the wrong side of the balance sheet. There's a legislation effort to make a deterrent to this sort of behavior and make company management liable for delaying bankruptcy petition. So I would like to ask you, do you have any track record how many people in Netherlands were put in jail for that?
Yes, probably it's zero, right? Zero. Maybe one, but it doesn't happen. And I know why it doesn't happen. So this is kind of the holy grail, right? Every legal system is looking for a dissolution so that debtors that are insolvent go to court at the right time and ask for help at the right time. And it doesn't work. It probably doesn't work here, doesn't work in the Netherlands, doesn't work anywhere. And there's good reasons for knowing why it doesn't work, because there's a lot of biases among debtors that prevent them from filing a bankruptcy at the right time. So, for example, the optimism bias, which holds that, it entails that you're always optimistic about yourself and your odds, right? So when you ask car drivers, 70% of the car drivers think they belong to the top 50% of car drivers, right? And it's just not possible, right? Also, optimism is associated with self-image, right? So people who are not so optimistic about things and about themselves, they're more often depressed than other people. So what we do, and it's kind of what you see in the casino, you know, when you lose a lot of money at the roulette table, you think, you know, just one more time and it'll come to black, right? And I'll earn the money. And that's casino behavior, and you see that in insolvencies as well. Like, okay, the company is not going very well, we have financial distress, but, you know, we just need this one more break and then we'll be fine. And you will not prevent that with any incentives, monetary incentives, jail time, because people just don't recognize that they're in financial trouble. So, and honestly, I've looked at all these systems. I've never seen a solution for this problem. So my advice would not be to stop thinking about it, but don't expect to come up with the perfect system that will really help. And jail time, I hypothesize, will not help anything.